SJC-12828, Atlanticare Medical Center v. Mark Reynolds.
Good morning, Your Honors. May it please the Court, Douglas Martland, Assistant Attorney General for Dan Tsai in Mass Health. This is the quintessential case of a judgment no longer being equitable. Mass Health, under state and federal law, is a payer of last resort. What that means is that the state medical agency does not pay for services until every source of third-party liability has been exhausted. And when the state Medicaid agency discovers after it has paid for services that there is a third-party liability, it must recover that money from the provider.
Even if we went back to 2001 and before Judge King, didn't everybody sort of know that you couldn't directly bill Medicare? And the issue is, how is it that the hospitals could recoup the money so that it would ultimately get to Medicaid?
Certainly, Your Honor, Mass Health's position throughout both the pre-Atlanticare period and the post-Atlanticare period is that it could not recover directly from Medicare. However, and I would point this Court to two aspects, both footnote 15 and page 11 of the Atlanticare decision, this Court concludes that it is uncertain whether Mass Health can recover directly from Medicare. And following Atlanticare, Mass Health did exactly what this Court directed. It filed a lawsuit directly, or it pursued claims directly.
We never asked you to do that. We never asked you to do that, did we?
Effectively directed, Your Honor. That the only mechanism in this instance where there was a third-party liability.
So is that even the only mechanism? How about the demand bill? Did you ever try doing the demand bills?
Mass Health engages in demand billing right now, Your Honor.
Okay,
yes.
so you do that. And that is an avenue to do it, isn't it?
Excuse me?
That's an avenue, that's an expeditious avenue of doing it.
That is one avenue, Your Honor. However,
you're not without ways of doing this, in other words.
Yes, Your Honor. Demand billing works as long as it is made within 12 months of the date of service. So if the retroactive eligibility determination is made more than 12 months after the date of service, Mass Health has no avenue for recovery. And that's what this request for relief from judgment is about. It is seeking the opportunity to void claims.
Can I ask the amount of money, because I couldn't tell when you're in your brief, the amount of money you've lost by this retroactive billing problem is how much money per year?
Mass Health has made a determination that for these services after 12 months of the date of service, it is about $5.3 million per year that it has lost, or it is unable to recover. And Mass Health is seeking to be able to recover that money prospectively. To be clear, Mass Health is not seeking to go back in time and recover that money.
That's with demand bill. That's with demand billing.
No, this is just for the situation for services for after 12 months of date of service. So if Mass Health could void claims, as is permitted in every other state, it would be able to recover an additional $5.3 million per year from providers who could then go and recover that money from Medicare.
Is Sebelius, is there any circuit split out there? Is Sebelius, let me just finish the question because I'm just trying to understand. Is Sebelius sort of the way the federal appeals courts, all of them have interpreted this, that no one can sue Medicare directly? No state can sue Medicare directly?
As far as I'm aware, Your Honor, the only circuit that has directly addressed this issue is the First Circuit. Mass Health here is bound by both the First Circuit's interpretation of the federal law and this court's interpretation of the federal law in Atlanticare, and that's where it is really stuck between a rock and a hard place.
So, but again, just so to make sure I understand, Sebelius concluded this, and I understand that, but has any other federal court addressed this issue?
No, Your Honor. And Mass Health, in anticipation of its motion for relief from judgment, conducted a survey of all the other states. Its survey determined that other states are engaging in this exact practice and that no other state faces an Atlanticare restriction on its ability to void claims.
So articulate precisely which part of the previous Atlanticare decision you're asking us to change. So you're not asking us to change with regard to any third-party provider other than Medicare, correct?
Your Honor, the upshot of the relief that Mass Health is seeking is that the logic would apply to all liable third parties. However, in these circumstances, Mass Health already has a statute, General Laws 118E, Section 22, that allows it to pursue insurance companies or other liable third parties besides Medicare directly. So as a practical matter, it needs the relief to pursue Medicare. And that's because certainly the state legislature can't grant Mass Health a right of relief against the federal government.
What happens in the other states?
The other states are allowed to void claims, which this court prohibits.
Well, wait a second. When you say demand billing and you're talking about 12 months, what is the significance of the 12 months? Why does that stop you? I don't understand why you still can't ask the recipients.
So Medicare has a regulation that
It's a federal regulation, you're saying?
under federal law, as long as the demand bill is made within 12 months, the provider can go to Medicare and recover. In order to trigger an exception to the 12-month rule, Mass Health, the state Medicaid agency, has to void the claim, and then the provider can go, and there's an exception to the 12-month rule, and the provider can recover from Medicare. That's the significance of the 2011 regulation that Mass Health is relying on here.
So you're saying you can't even ask the providers to do that?
Where the retroactive eligibility determination is made more than 12 months after the date of service, Mass Health cannot recover the money. It cannot ask the provider to do it because the provider, unless Mass Health could void the claim, doesn't have a right to obtain payment from Medicare.
To void the claim, what does that mean, to void the claim?
So Mass Health would take the money back from the provider, void the claim, direct the provider to recover the money
You want to take the
from
money
Medicare.
back from the provider?
Yes. Excuse me?
You want to take the money back from the provider?
Yes.
Provider could be like a sole practitioner or something like that,
Yes.
and you still think it's right to tell us that we should be able to have you do that?
Yes, and to be clear, the state here is operating in the scheme that the federal government has created. The federal government, in the context of Medicare, has determined that the system is for the provider to pursue the claim for Medicare. As is shown in Sibelius, the state cannot do that directly. Certainly, I acknowledge that would be perhaps much more efficient, but this is the scheme that the federal government has created, and Mass Health is seeking to act just like every other state and operate within that scheme and be able to recover the money that's entitled to.
Sibelius was talking about you never having done the demand billing at that point.
Yes, in the
And
record,
is that part of the record that you do that? And
Yes.
how it works? Where is that?
the record, I believe, is, it's cited in our brief multiple times, Your Honor. It is in the Greco affidavit, the second Greco affidavit.
So is that why you waited from 2011 until 2020 to bring the,
No, Your Honor. The Affordable Care Act prompted a sea change here in the federal health care space, requiring Mass Health to consider such questions as the fundamental eligibility for Mass Health. And so issues like this temporarily and unfortunately got pushed to the side while Mass Health dealt with those very significant issues. It arose more recently again in 2017, and Mass Health pursued its motion for relief from judgment.
when
But-
did you start doing demand billing?
I don't know the exact date, Your Honor, but after the Sibelius decision in 2011.
But when after that? I mean, are we talking about
I'm
years?
sorry.
Are we talking about months? Or you have any memory at all?
I'm happy to provide the court a letter with that exact date if that's requested, but I don't
All right,
know
Chief.
that off the top of my head.
We get the letter? Yes.
Ms. Martin, let me go back to what I initially was asking about. So the hospital proposes a solution here, and I expect your response to the solution is, well, it won't work for any outstanding liability beyond 12 months. But their solution is, why don't you just give us an assurance that if we can't recoup the money, you'll reimburse us, and it'll all work out fine. I'm sort of colloquially putting what their solution was.
I viewed their solution slightly differently, Your Honor, which was that they wanted to be compensated for doing the work that they're required to do under both federal law and under their provider contract that they've agreed to, right? All providers here participate in Mass Health voluntarily. They have a choice whether they want to participate in the program. In that context, Your Honor, they do so knowingly, and this is one of the rules that they agreed to accept.
All right, so you interpreted the solution to be, well, if they have to deal with Medicare and be reimbursed, the expense of having to do that for the hospital, the provider have to do that, has to be reimbursed by Medicaid?
We certainly don't agree with that.
I know you don't agree with it. I know you don't agree with it. I understand that. You're not agreeing that that should be an expense of Medicaid, but you're saying that the problem with the hospital solution is not simply that Medicaid would promise to reimburse if the hospital or the provider wasn't able to collect from Medicare. The problem is that they're also asking that you pay the expense involved in seeking the recoupment.
Well, ultimately, Your Honor, the problem with the hospital solution is that it's really secondary to the fundamental question before this court. The fundamental question is whether Mass Health has the authority under the federal law to engage in this specific conduct.
Is the question whether or not the motion for relief from judgment was an abuse of discretion?
Yes, Your Honor.
So we have to take into account a number of issues, including Justice Link just mentioning Sebelius was in 2011. I'm not sure it's just simply that precise question.
But where Mass Health has established a change in circumstances, and Mass Health here has demonstrated that, it's demonstrated the Sebelius decision, it's demonstrated that the fundamental assumption underlying the Atlanticare decision is inaccurate, and it's demonstrated that there's been a change in regulation that allows every state to engage in this exact conduct. A court abuses its discretion when it fails to give weight to those circumstances and grant Mass Health prospective equitable relief.
Are you saying that you want the regulation back, the state regulation back? Is that the relief that you're wanting?
To enforce,
We set aside a state regulation. And
that is correct, Your
that's
Honor.
what you want back. You want the regulation
Mass
back.
Health wants the authority under federal law to follow the regulation.
Through the state
Yes.
regulation.
Yes.
Why do you need the state regulation if the federal law allows you to do this?
Federal law allows us to do this. However, there is a declaratory judgment, and that is what Mass Health is seeking relief from, that prohibits Mass Health from engaging in this conduct. And in the abundance of caution, Mass Health has sought relief from that judgment so that if it were to prospectively engage in this practice, it would not result in a contempt proceeding where Mass Health could potentially be penalized for engaging in the conduct that every other state can engage in and that federal law allows. Again, Your Honors, Mass Health here is the payer of last resort. It has the fundamental obligation under federal law to recover these monies when a source of third-party liability is identified after it is paid for services. Interpreting the federal law in this instance in a way that artificially narrows Mass Health defeats the fundamental principle of payer of last resort and precludes Mass Health from recovering monies that would be devoted to the most needy in the Commonwealth.
Are we bound by the Sebelius decision?
Your Honors, this court treats federal circuit court decisions from the First Circuit persuasively, but more importantly, Mass Health is bound by the Sebelius decision. Here it is between a rock and a hard place between the Atlanticare decision, which precludes it from following the regulation that every other state is able to follow, and from the Sebelius decision from recovering from Medicare, which is what this court effectively assumed it could do in the Atlanticare decision.
But totally apart from the Sebelius decision, if you were to actually go to Medicare to say, in fact, now we seek to recover from you, they would say, forget about it.
That is correct, Your Honor.
So you don't have the recourse regardless of what Sebelius says. Medicare's not going to pay you.
Right.
They're going to say only the provider can be paid.
That is correct. However, and this is the critical point regarding the Atlanticare decision, that point was uncertain at the time of Atlanticare decision. There was a concession made by the Assistant Attorney General during oral argument that Mass Health had never attempted to do that, and therefore that he could not say for certain whether or not that avenue was foreclosed. Even though, again, it was his position that it was, there was nothing that conclusively established
Right,
that.
I gather both sides basically thought you couldn't do it, but there was the concession made that we haven't tried.
We haven't tried, and this court relied on that concession heavily in rejecting the argument that Mass Health advanced at the time, which has since proven correct. If there are no further questions, I would ask this court to vacate the Superior Court's decision, find that the Superior Court abused its discretion in declining the prospective relief, and grant Mass Health prospective relief so it can exercise the regulation prospectively moving forward.
All right, thank you.
Thank you.
Ms. Kent?
Good morning, Your Honors. Charlene Kemp for the Appellee Hospitals.
Could you put the microphone a little closer to you? Thank you.
Sorry, I'm a little shorter. So we're here today again, since 2003, to revisit the same issue that we've briefed over and over and over again. The fact is, as you had asked about why has it taken so long since 2011 to bring this motion back again before the court. 7 years is not a reasonable amount of time when you're a litigant to the case.
They were busy.
The Affordable Care Act was a sea change.
That's true, but they were so adamant that this was something that needed to be done, that they needed to get this reversed, and they waited 7 years. And meanwhile, the hospitals are continuing on providing their contracts and providing care to their patients, knowing that this was the status quo, and then being hit with this 7 years later, stating that they want this changed again.
But why can't we have the same procedure that Nebraska has?
I'm not familiar with Nebraska's procedure.
Any state.
Oh, so I don't think that any
I
other...
just picked the
honestly-
heartland.
Honestly, I don't think any other states has challenged this, which is why they haven't gotten any feedback on this. So just because the hospitals are proactive in seeking relief from procedures that are cumbersome to them. So for example, if you look at
So you don't accept the representation that every other state has the ability to avoid a claim and then make the hospital chase the provider chase Medicare?
I don't know what other states do, and I don't know if any other states have challenged it, but the Massachusetts hospitals have challenged it, because if you look at what was going back to the original Atlanticare case, the hospitals presented a case to tell them, to demonstrate how much cost burden went into these. So even if you look at what the appellant has provided on page 26, 2 examples out of all of these 5 million potential identified. So the first example, the retroactive Medicare goes back to 1993, but it wasn't posted on the system until 2017. So does that make you wonder, why is it taking so long? Is there not effectiveness in the system, and then now the hospital's going to bear the burden of finding out years and years after they provided services?
But don't we have to look at the statutory scheme? I mean, and my question had to do with the 12 months and the significance of the 12 months. And they're saying basically, yes, they're now doing demand billing, which is Sebelius is saying, well, you never tried it, why don't you try that? And they said, okay, we have. And there's still this problem that if it's more than 12 months, as in your example, as in their example, they're stuck, they can't.
That's correct. Well, I believe
What
that
do you say about the statutory scheme with respect to that? That under federal law, they're allowed to just avoid the claim?
the statutory scheme is under the demand bill is only for less than 12 months date of service, and after that, after the 12 months, then they have to recoup you have to give the money back to the state, and then you have to go about billing Medicare. So the problem from the hospital's aspect is that once a claim ages out a certain way, it has to be recreated in their system. There's an extra administrative burden. Even though, we've come a long way with technology, it's not just press a button and the claim goes out electronically. So there's still an added expense. So, and then the older a claim is, different claim rules come on. So a claim that would have paid 6 months ago, there's now a new claim rule and it has to be changed. So it's the administrative burden for the hospitals continues to carry on.
But given the federal regulations, why shouldn't the provider bear that responsibility as opposed to Mass Health that can't recoup after 12 months?
Well, because the distinction in these Atlanticare claims are, at the time that the service is provided, Mass Health is the primary provider. It's not until after the claim is paid that there's retroactive insurance. So at that point, then the hospital has done everything that they could do possibly to get the claim paid. And as my brother stated, they have, for other insurances, they have a way of doing that. And normally what they do is they actually hire agencies and they pay them a fee to do that. So they,
To do what? To get it back from? get this
yeah,
good.
they have, like HMS, they have different agencies. I don't believe, I don't know about currently, but back at Atlanticare, they had agencies that would do the billing for other
They have to. They're the payer of last resort. They have a statutory obligation to seek funds from third parties, mostly Medicare, but sometimes other insurance, right?
Right, so now you're making the hospital bill twice, the same thing that they've already billed. And so this is when we want to talk about the cost effectiveness
But
statute.
isn't that that's where we were the last time? I mean, I understand, the problem is, you're the only one who can do anything.
Right.
The feds have said the state can't step in and do anything. Why should I understand this creates an additional administrative cost for you, but why should the state give up $5 million a year that the feds are willing to pay for no reason except for there was uncertainty when Atlanticare was written earlier, and now we've found out we can't do it?
Well, I think there's two things that we talk about. The first is the cost effectiveness. So you need to look at the age of the claim and how much they are. So for example, the first example they provided was a claim that was 2 years old. There was 30 claims that paid $500. So each claim averaged $20. So then you have to think about how much is it going to cost to bill each of those claims.
But that's built into the regulation. Medicaid has to do that analysis before they go after it.
But there's no assurance.
Don't they have to do that cost effectiveness analysis?
It's supposed to be, but if in the past I've seen before Atlanticare, there were small balances and they'd make you go back and rebuild them. So, I mean, if there were some assurances, a certain age, date of claim, how far back they go. And as they stated in oral argument, it doesn't apply to third-party insurance and they have their own way to do that. But however, what if budget tightens up and they can't afford to do that and the statute is still on, and then they're going to say, okay, we are now going to put the burden back on the hospitals. There's nothing that will stop them from doing it other than their assurances that they're not going to. If the declaratory judgment is reversed, they will be able to. They're saying they won't do it, but there's nothing that will prevent them from doing so.
When we're deciding whether there's relief from judgment as to this declaratory judgment action, do we just consider what's equitable, or do we also consider within that framework the amount of time that's gone by and its impact?
I think both things have to be considered.
Even though we know that Medicare is not going to reimburse Medicaid? And we're talking about...
Yes, because there's other avenues. There's other ways for the Mass Health to work with the providers. Mass Health just refuses to work with providers and just keeps seeking legal action instead of meeting with the community saying, what can we do to resolve this? They're the ones who write their regulations.
But
and
what about the
12
12-month bar, where they can't, where it goes past 12 months and it's over?
They can't ask.
They can't ask.
No, but they can work with the hospital saying, okay, what can we work with that's going to be cost effective for both sides? What are rules that we can come up with that we can coexist? There's been no conversations. It's just, let's reverse this, let's reverse this, let's reverse this. And instead of having, they're the ones who can write the regulations.
But again, if they can't, this is lost money, right? We've got to, we want to collect as much money as humanly possible. You want to collect as well as they want to collect. By the way, you can build your administrative costs into your rates, right? There's an administrative component.
That wouldn't change what Medicare or Mass Health would pay.
Well,
They
no,
pay us-
but
they pay
the
their
rates you charge for every service has an administrative component to it, doesn't it? Like when,
Right, but,
yeah,
I mean,
so you could arguably, if this is going to require you to hire more personnel to do this, that's gonna change
You can't
your
negotiate that amount, though, with Mass Health or Medicare.
we don't negotiate it, but it's part of the overall calculation of how much you get paid, isn't it?
No,
And this is a pain administratively to do. And you don't like it because each $20 to you is a certain amount, but, I mean, again, there's no alternative. We don't want to revisit the mistake that may have been made in the past, do we? Which is thinking there's another way of doing this. There really isn't. If we want to recover the money, we have no choice, right?
correct. They need the hospital's assistance. However, the way that they're going about requesting it is not the right way to do so. I mean, they have to understand that there is an additional administrative burden for the hospitals. They have to review the cost effectiveness statute, federal statute, because instead of just foisting this billing back on the hospitals, they have to understand that there is still a cost associated with it. And when they,
Okay, I mean, that's fine. We understand that it's not good for the hospitals. We understand that. But I mean, the question is what the law requires or permits. And I think your brother's basically saying that after 12 months, they're not even permitted to work with you or ask you to do anything, right? Unless they have the power to void it,
correct,
they have nothing.
right, correct,
And you're saying they have nothing.
correct.
I want to know why they have nothing.
They have nothing because they haven't come to the hospitals to
How
ask.
can they if they're not allowed to ask?
They can, in a different way, they can propose new regulations. That's their administrative right to do, create a new regulation.
What would that regulation look like, given the federal regulations that bar them from going after money after 12 months?
Well, that's for them for the demand bill, but this would be for them to say if, it can be exclusive for Medicare. So make sure now we've taken out the third party, so that's not going to be out there for Medicare. When the cost analysis is, the data service is a certain date or the cost is a certain amount, you can make tighter parameters so that it's beneficial for all parties.
But I'm confused. Can they do that if they have an obligation to seek reimbursement? I take it you want to say, if we do this, we want to be compensated for this by you, right? But they can't do this under federal law because they have to be the provider of last resort. So if we're going to recoup this money, they can't do what you're asking them, can they? Can they literally do what you've requested, which is to eat the administrative cost?
Is it more cost effective for them to do
No,
that?
I'm asking a legal question. Can they legally eat that cost under federal law and still have this money reimbursed for everyone? The answer is no, isn't it?
I don't know. I'm not aware.
But that's the problem with the last time. Not knowing led us into sort of gray area where we made a mistake. So we got to be careful here, right? We don't want to come up with a solution that's illegal under federal law.
Right.
So if you want to get reimbursed, is there something, as Justice Lank said, that they can do that's legal under federal law that we could write for you that would be beneficial for you?
I think the best way to do it is to set, I do believe that there is a way that they can set it. I think it's to say that, a certain age of claims, not going back 5 years, 10 years, within, say, 2 years, or 3 years would be a reasonable amount of time because you may be eligible for retroactive Medicare because you're deemed disabled. It takes 2 years to be deemed disabled, so 2.5, 3 years is a reasonable amount of time.
But Medicaid has
eat
a
the money.
statutory obligation to go after any available third-party providers. There's a statutory federal obligation and regulatory obligation. We can't say only 2 years.
Correct. But, I think at a certain amount of time that you need to have, every other insurance company will not let you bill within a certain amount of time. So, maybe it's working even with Medicare, saying what are the timelines that need to be done. That's what I'm saying. This isn't really, this should have been something that you worked with outside the judicial system instead of resurrecting a case from 2003 to work with the providers, the Medicare
But here we are.
community.
Here we are now.
Yes, that's
Right.
true.
But you kind of like the way it's going now, so what's your incentive to go to the table?
Because we need to work with Mass Health, because that's, hospitals take Mass Health patients, they need to be able to work with them instead of.
Must they take the patients?
No, they don't have to, but
Is there any statistical information in the record that would suggest that we would lose providers if providers had to do what the state wants?
no, there's no statistical information in the record. Unfortunately, there wasn't time to establish the record after 2001 for the providers to provide statistics, because we didn't have any of the statistics about how much would have been affected by Medicare. So we can't even challenge or understand what the $5 million identified by Mass Health was. We didn't have access to what the extrapolation was or how they came upon those numbers.
What you don't take into account in your argument, though, is under the federal statute, under 1396A25B, Medicaid agencies and states must take all reasonable measures to ascertain legal liability of third parties to pay for services. If it's 5 years out, they still have to take all reasonable measures.
Right. So they have the obligation to make it, not just to push it back. So what happens is they keep putting the burden back on the hospitals.
Well, Judge Squires-Lee actually made that point in stating that if this is just recoupment, then there never has to be a cost-benefit analysis under the federal statute. She made that point in her denial.
Correct. It
Well,
is.
I'm trying to understand, if we were to give you a robe, are you saying that what we should do is that in the Atlanticare decision 2003, we were under the mistaken assumption that Mass Health could bill Medicare directly and seek recoupment from them, and that turns out to be wrong, and we should say we're still going to stick with that decision even though it turned out empirically to be wrong?
Yes, I believe that the decision was correct. Even every argument was made. There was just one question saying, could you bill Medicare? I'm not sure. You know, they never tried it, I think, is what happened. But the underlying decision is still appropriate. The declared judge,
Okay,
the
but
declaratory
to
judges
the
should still
extent
stand.
that that decision said that they now must directly go to Medicare and cannot seek to recoup it from you, that part is factually incorrect. They can't go to Medicare and get paid.
Correct.
And you're saying we should simply stick with something even though it turned out that we were wrong in 2003.
Yes, because everything else associated with the decision was correct. The regulations still have not changed. Just because they can't get payment directly from Medicare doesn't mean that they're not able to get payment through the hospitals if they willingly engage in the relationship with us so that it's beneficial to both parties.
Doesn't Medicare pay more than Mass Health?
It does, but when you're saying proportionally on, for example, these $20 claims, I mean, maybe $1 more, I mean, it's not, I don't think it's an amount that's gonna make.
So for you, the real challenge is not the $10,000 hospitalization, it's the...
It's the small ones,
Smaller
right,
ones.
exactly.
Okay, thank you.
Thank you very much.